All right, everybody, we welcome to this evening session, our tutorial for this week for the free training group. We've got quite an interesting topic today. It's a bit different to what we did last week, in the sense that what we have been doing up to now is sort of work which is of general application, so general principles. Today, what we're going to be looking at is an important judgment that came out yesterday, handed down by the Western Cape Division of the High Court. And it's important, it's interesting, and it's worth looking at this judgment in some detail for two reasons. The first is just the judgment itself and the technical side of it. It's something that is very much in the news. It's attracted a lot of attention. It's a bit of a lightning rod for news items and what have you. It's also quite symptomatic of what's happening as far as the Road Accident Fund is concerned, and the sort of general atmosphere between the courts and the Road Accident Fund. And what, for those that litigate Road Accident Fund matters, we're very familiar with, which is a question of procedural aspects of Road Accident Fund work comes very much to the fore. There have been numerous judgments on this, and this particular issue, as I say, has been a bit of a lightning rod. So for a number of reasons, on the issues themselves, on the legal substantive issues, it's important, but also just from a broader perspective as far as the kind of context of this litigation is concerned. And then there's a third reason, and that it is useful to look at these judgments, even for expert witnesses, to understand how the court process works and to really get into the mind of the judges and to have a look at the different levels of the judiciary, how they think about issues, how they analyze issues. And a point that I've made quite regularly over the last few weeks and now 2 months or so is that it's very important for experts to understand how the court approaches the resolution of disputes. So here, it's more in the domain of a legal dispute, but nonetheless, there's some very important principles which emerge insofar as how the judges tackle these issues. And we're going to go quite closely through the reasoning process of the judges in this judgment. Now, just before I start, this judgment is quite technical in nature from a legal perspective. And I know that most of you are expert witnesses, and you may feel a little intimidated or a bit out of your depth as far as the approaching the actual hard technical side of the law is concerned. I would just like to say from the beginning, and I have said this often in my presentations, whether live or training or whatever, is that I would very much encourage you not to allow yourself to be too easily intimidated. There are technical terms which I will explain. And I would like to believe that it will not be difficult for you to properly grapple with the issues that are at stake here. And there are important issues, and they are symptomatic of what's happening within the law. But it's also, as I say, something which demonstrates a particular point, but broader than that, demonstrates an approach which the courts take. So I'd encourage you to engage intellectually in the content. I think you may be quite pleasantly surprised to realize that at the end of the day, it's really a question of judgment. It's a question to a large extent of common sense. There are legal principles and there are technical aspects to it, but you'll see once you get through those technical principles and understand them, they're not really all that difficult to understand, in my view. And even though this is at a high level, and then it's a question of a reasoning process and of applying sound judgment and common sense. And what I often feel, and it's a sort of a guide that I apply in my practice when I appear in court, is I do try to present the case, the solution to the case, as being simple justice between what they say between man and man or between person and person. And that is something that I've always found through my whole career is something that is very, very powerful insofar as persuading a judge. Is if that judge is feeling that we're getting the fair result here or the just result, then that puts you in a very strong position. And as expert witnesses, I think you should bear that in mind when you prepare written or oral evidence. Is one of the things that you are wanting to appeal to, and I would say probably the main thing, is that sense of justice between being done by the judges. Because believe it or not, that judges are human being. They have their own feelings and views, and they are, and I can tell you, in the overwhelming majority of the time, they very much appreciate the burden that is on them, and they try to acquit themselves of their office as best as humanly possible. But it's not always easy. They're difficult working conditions, and one should bear that in mind. And as I also say, try and be of assistance to the judiciary. All right. So without any further discussion, let's go straight into the judgment itself. I think people should have joined us by now, whoever's going to be joining us. And I put on the group that a link to the website and to the sorry, it says I called this up. I thought I'd opened it, but I must have closed it by mistake. I apologize for this. But I put a link up on the WhatsApp group, which will take you to the tutorial page for this particular tutorial. You'll see there are 2 tutorials up. I've left the one up for the 20th of January because it relates to some coursework. Those who've been doing the advanced training will know that there's coursework dealing with that particular tutorial. So I've left that easily accessible. And then we get to today's tutorial, which is the 10th of Feb's tutorial. And we'll just wait for that to open up. Here it comes. And then let's have a look at this. So there are two tutorial materials today. The first, I have put on the group a link to the PDF version, but there's also a copy of the judgment in the tutorial materials. And then there is the analysis of the judgment, which I've set out below that and which we'll go through this evening. The judgment is lengthy. It runs into over 100 paragraphs. There are some paragraphs, obviously, that are more relevant to this evening's discussion than others. And I'll try and navigate my way through it. I will summarize certain aspects because it would take us well over an hour to go through all the tutorial notes on the page. But for those that are interested, the notes are there in quite full form. It's quite a full summary of the judgment. And by the end of this tutorial, you should firstly have quite a firm grasp of past medical expenses and how the courts are approaching that issue within road accident fund work. And you should also get like a quite informed view of what the judiciary, how the judiciary approaches a number of these aspects. All right, so let me just line myself up here, because I think what I'm going to do is I'm going to go through the judgment on screen, and then I will work off my notes. Just give me a moment. Let's get this to full screen, and then we can start. All right, well, the first thing to notice whenever we start looking at a judgment, it's very important to just locate ourselves, where in the hierarchy of courts we are. Now, for expert witnesses, you won't directly be dealing with appeal courts. So you'll by definition be appearing almost without any exception before a single judge within a particular division. But you'll see that hierarchy of courts is important because, as those that have been following these tutorials will by now have realized, the legal profession and also the judges, the judiciary, place a lot of emphasis on what level of the hierarchy that we're dealing with. So, what sort of court are we dealing with? What level? And here we see that we've previously been looking mainly at Supreme Court of Appeal judgments, but we are now going into what's called a full bench judgment. In other words, what's happened here is that there was an initial judgment handed down by a trial judge, which is the level that most experts will engage at. So that's your sort of first tier of the court process. Experts will then testify before a single judge, and then there's not an automatic right of appeal. If one party feels aggrieved by the judgment, then they need to motivate by way of an application for leave to appeal before that same judge that there's a reasonable prospect of another court coming to a different conclusion. Now, as you can imagine, that can be a difficult task. Some judges are quite hard-headed about their judgments, and there's a particular skill set that goes with trying to persuade a judge that he or she has potentially got the thing wrong. But the important point is that here leave was granted. There were some complications around that in this particular around this past medical expenses issue, which we'll get into, but nothing too central. It kind of went up and down the chain, and leave was granted not refused initially by the lower courts, and then the Supreme Court of Appeal granted leave. I think probably because of the public importance of the issue. But that then is where this originated and where it ended up now. Yesterday, the Western Cape Division handed down judgment, and you'll see that it's the Road Accident Fund versus Nicolaas Johannes van Wyk. You can already see from that's an appeal judgment, because it's normally the plaintiff is the individual and the Road Accident Fund is the defendant. And the other thing that's interesting, just from the heading there, is it tells me that the Road Accident Fund lost this case because they're the appellant. So even just from the heading, there's a bit of information that one can gather. And then you'll see what I was saying earlier. Look, if you see the neutral citation, well, that's just the way that the case is referred to. And that is a neutral way. Different law reports have different ways of referring to cases. This is as the name suggests, it's neutral. So it's not, obviously these judgments are commercially available, but this is one that comes out on SAFLI. And in fact, the court gives it this particular case number, and it can be used in your reports. It is, if you are going to refer to judgments, the usual way really is to refer to one of the commercial names for the judgment, but this neutral citation is also acceptable. And then you've got the quorum, which is the court, Dolamo J, Lekuleni J, and Ziweni J. So 3 permanent judges, no acting judges there. And they're all at the level of permanent judges, but there's no judge president or deputy judge president or anything like that. But you'll see that's what's called the full bench, because there are 3 judges sitting and hearing an appeal against a decision by a single judge. It was heard in September 2025 and delivered electronically yesterday, the 9th of February 2026. That is not an untoward length of time for a judgment of this nature, because recess was in between, and it appears that they worked on this judgment over recess, then got together once the term started and finalized the judgment over the last 2 or 3 weeks, and they've now delivered this judgment. There's a summary: appeal against payment of past medical expenses. So there's an appeal against payment of past medical expenses, or PMEs, as commonly referred to. Court setting aside the RAF's first directive to reject claims for past medical expenses settled by medical aid scheme. All right, so I'm sure many of you are aware, but in case there's some that aren't, that there was a directive issued by the Road Accident Fund relating to whether past medical expenses should be paid or not. What's also important is there was an initial directive which went to court, and we'll have a look at what happened. But subsequent to that decision, there were 2 later directives. So the first directive, and then a little batch of 2 after that, and that'll become important. The Road Accident Fund contended that the 2 subsequent directives did not breach the court order setting aside the first directive. So what happened here is the first directive related to past medical expenses, and basically what that directive said is that past medical expenses, where they've been paid by a medical aid scheme, should not be paid by the Road Accident Fund. And it was just a sort of standard ruling. We'll have a look at the details there, but that's the effect of it. And that went to court, and the court initially said that couldn't stand, that for various reasons that those past medical expenses should be paid. And then there were 2 subsequent directives that sort of achieved the same thing, but weren't identical to the initial directive. And that becomes important in this judgment. And you'll see how this particular court deals with it. And it'll also locate you within the broader context of what's happening with regards to past medical expenses. And then the res inter aedos acta principle is discussed. We'll have a look at that, but that basically means that once whether a payment should happen from a collateral source, we will have a look at that in the reasoning of the court, and why the initial court said that amount, that the past medical expenses should be paid, even when a medical aid scheme has risked the plaintiff, which on the first might seem unfair. Because does that not amount to double compensation? In other words, Here you've got a person who has medical aid, is involved in a road accident fund, and has been paid now by the medical aid, but now claims the full amount of compensation from the fund. And the fund said this is unfair. It amounts to double compensation, and the courts are split on that question. We will have a look at why it is that the courts are split, and apply your minds to what you think the appropriate and fair solution to the issue is. But wait till the end, until you've read, in my view, Zondi's comment on this in one of the cases, which, to my mind, summarizes exactly the position accurately. It'll be very interesting to see what the Supreme Court of Appeal eventually makes of this issue. Just on that point, this is not the final word on this issue. This is an important judgment, but there is a judgment pending before the Supreme Court of Appeal, which I don't know when it's set down for, but it's coming up and it should be fairly imminent. And the Supreme Court of Appeal will then decide this issue, and there may very well be a further appeal to the Constitutional Court. But this is a very good judgment to be familiar with, because it will give you a very well-reasoned understanding of what all the main issues are that keep coming up in all of these judgments. So when the Supreme Court of Appeal judgment comes up, you will know what the issues are. When it's argued and judgment is handed down, you'll understand what's going on. All right, let's then just move into the order, and you'll see that the appeal was dismissed, and then that the costs were awarded against the road accident fund in this case. Okay, now this case, and I think if let's just move down to paragraph 1. All right, so this case involved an appeal by the road accident fund. In fact, I think what I'm going to do is I'm going to do this a bit differently. I'm going to actually go to follow on my notes. I think that's going to be a bit easier. Just give me a moment, please, just to get down to that. I'll take you through the tutorial notes. All right. Okay, so you'll see that this matter involved an appeal by the Road Accident Fund to the full bench of the Western Cape Division against a judgment and order handed down by Tumunya AJ in respect of the delictual claim in which the appellant was directed to pay the respondent's past medical expenses in the sum of approximately 350,000 Rand, and then interest on that amount. So a very, very standard order that we encounter all the time. Past medical expenses, nothing really to see here, one would have thought. And then just the facts that happened, very standard facts. There was a motor vehicle accident. A car allegedly swerved in the path of the motor vehicle, the motorcyclist. There was a dispute of fact. The motor vehicle denied doing that, and that is all set out in those initial paragraphs. And then another interesting point is that you'll see from paragraph 3 that in bold, in its plea, the Road Accident Fund did not impugn the payment of past medical expenses paid by the respondent's medical aid scheme in line with the directives issued by the acting chief claims officer to all regional managers. So, I've taken you through that when these cases are initially undertaken, they start with what we call the pleadings. In other words, the summons and the particulars of claim sets out the plaintiff's case, then the plea sets out the defendant's case. Those documents are very important because they foreshadow the basis on which the claim is brought and then the defense is raised. And what's very interesting in this case is now the standard rule is that you can't go outside your pleadings unless you amend them. It's a similar principle to the expert report, where experts are held to the four corners of the expert report, and a similar principle also in respect of joint minutes, where experts are held to the joint minutes. And as we saw a few weeks ago, the court can even be bound by joint minutes where there's an agreement as to the facts. Well, in this case, the Road Accident Fund did not raise any issue around the validity of the payment of past medical expenses in its pleadings. And usually that will be an end of the matter. But you'll see, I think it's because of the importance of this issue. The courts actually allowed flexibility where very often they won't allow flexibility. So something to notice, just an unusual and interesting aspect of this case, but that is very much the exception. And the rule is that what's in the pleadings sets out the four corners of the case. That is 95% of the time, if not more, that is followed unless there's an amendment which is sought. That's relevant to experts because you can be guided by what's in the pleadings. That will give you a very reliable indication of what is before the court. And then what happened is the matter then eventually was enrolled for trial. And here's another interesting aspect of this judgment. It doesn't get very much airtime, but it is very interesting. Is what happened is that the defendant's insured driver was actually not in South Africa. He was in Zimbabwe. And you'll see in bold, the RAF's attorney requested leave from the court to lead the evidence of the insured driver through the virtual platform. In other words, this is something that came up in COVID, is that there is the option now to lead evidence virtually. However, the court of quo refused the request. The court of quo is the trial court. So the single judge refused that request and wouldn't allow evidence to be given via Zoom or whatever platform they were going to use. Subsequent thereto, the RAF applied for a postponement of the trial. So what happened is they wanted the driver was in Zimbabwe. They wanted to lead his evidence virtually. The court refused that, and then the defendant's representatives applied for a postponement of the matter to get the actual live witness down from Zimbabwe. The trial court also refused the application for a postponement and finalized the matter after hearing only the respondent's evidence. The respondent's evidence was the motorcyclist, who was initially the plaintiff. As I explained earlier, the plaintiff won this case, and so when it goes on appeal, the defendant becomes the appellant and the plaintiff becomes the respondent. So already that's something that is, to some people might feel it's a bit jarring. I mean, there's only been one side of the story here. Is that not fundamentally unfair? And not to sort of give the game away on everything, but this court, the full bench, actually found that indeed it was unfair, and that violated fundamental principles of a fair trial. And the full bench, in fact, found that the court was wrong. The court of quo was wrong in refusing to hear virtual evidence and was wrong in refusing the postponement. But it so happened that, notwithstanding that, because all aspects then became settled except the question of past medical expenses. In other words, liability was then settled. Subsequently, the court said that, notwithstanding the fact that there had been this unfair procedure or process, that it was going to continue with the appeal, and in fact found against the Road Accident Fund in this case. So quite interesting how that can happen. And it may seem surprising, or to some people maybe even unfair, but there is a logical explanation for it. And that is simply that all the issues that were relevant to the dispute of fact, in fact, became settled between the parties and were no longer live issues before the court. And that's another example of something that I repeat, that you'll hear me repeat often, is be aware of what the issues are at any time in the proceedings. In this case, that relates to liability, so of less relevance to experts, but it demonstrates the point of these issues can change, and they have a very important bearing on what is actually before the court and the way the court approaches the judgment. And then, so the court granted an order on the merits, and in other words, on liability. And then it also granted an order in terms of which the Road Accident Fund was directed to pay approximately 350,000 Rand in respect to the respondent's past medical expenses plus interest thereon at the prescribed rate of interest. So there was now a judgment for past medical expenses. And then there were various appeal processes. I'm not going to go into that. It's not relevant to the points I want to make this evening. But there is at paragraph 7 an important point. The Road Accident Fund, then what happened is the Road Accident Fund went and considered its own practice directives. In other words, remember, these practice directives had not been raised in this matter previously. Now, suddenly the Road Accident Fund, it dawned on them that there were these practice directives, and the decision by Mbongwe J in Discovery Health, in terms of which the first directive which the Road Accident Fund issued was taken to court, and in fact, in that judgment, the judge found that directive was unlawful and set it aside. And that directive instructed the Road Accident Fund employees to reject road accident victims' claims for disputed medical expenses. So what happened there is that in this case, they hadn't thought about this point. The trial was heard, and now at the appeal stage, they suddenly dawned on them that there was this directive out there, and they now raised this question of the directive. And the first directive issued by the Road Accident Fund was a blanket directive that that all employees must reject road accident victims' claims for disputed past medical expenses. It was to the effect that all claims for past medical expenses lodged by claimants whose medical aid schemes had already settled them should be rejected on that basis alone. In other words, a very broad, far-reaching directive. And let's have a look at the reasoning, because there is reasoning and there is a point of view to understand here. Whether one agrees with it or not, we'll leave that to the courts to decide. I will give my particular take on this towards the end, but one must try and see this from different perspectives. The reasoning underpinning this directive was that those claimants did not suffer any loss, and that the Road Accident Fund therefore had no duty to reimburse them. Mbongwe J, so let's just pause there. This is something that I raised earlier. In other words, the Road Accident Fund was making the following case. Is that, look, we understand that this person has been injured, and we understand that this person has incurred past medical expenses. That's well and good. But this person has been compensated by his or her medical aid scheme. In other words, they've now recovered that money. Now, why must the Road Accident Fund then have to now go and pay them for past medical expenses? That's the argument made by the fund, all right? We'll get into why that argument is criticized and attacked and has not really got very much traction in the courts, although there are some courts that have sympathized with that argument. We will have a look at that, but that's the perspective of the Road Accident Fund. Mbongwe J reviewed and set this directive aside. So in other words, the Road Accident Fund's directive saying don't pay, Mbongwe J set aside in Discovery Health, and amongst others interdicted the RAF from relying on the directive to reject claims for past medical expenses. So now he set the directive aside and interdicted the fund from rejecting claims for past from issuing directives to reject claims for past medical expenses. So he went further than just setting it aside. There was also an interdict. And then what happened is there was then another judgment, which is known as Discovery Health 2, in terms of which the full court of the Gauteng division held the two subsequent directives issued by the Road Accident Fund on the 13th of April 2023, the second directive, and the 2nd of November 2023, the third directive, respectively, were not unlawful and not in breach of the order issued by Mbongwe on the 27th of October 2022. So let's now understand that. So what's happened is that we have this matter. There's an accident, there's a claim, this thing runs to trial, there's a judgment against the Road Accident Fund. At the appeal stage, they now want to raise the practice directives. These practice directives, there's an initial one, which says to all Road Accident Fund employees, if there's been payment by a medical aid scheme, don't pay out for past medical expenses, because that's going to be effect. They don't say this in the directive, but meaning that will be double compensation. That goes to court. Mbongwe J, for reasons which we will discuss, says that won't stand, sets it aside, and interdicts the fund. This is important. Interdicts the fund from issuing further directives invalidating such payments for past medical expenses. The fund then issues two further directives, and the question then is whether those two further directives are valid. That goes to court, and a full bench of the Gauteng division finds that the two further directives are actually not unlawful. So the first directive is struck down by the courts. The two subsequent ones aren't. So you can see that there's now lots of room for debate and dispute here. Paragraph 8, for completeness, the second directive required the Road Accident Fund's employees to first ascertain whether a claim fell within the prescribed minimum benefits or emergency medical conditions. And only where it was neither would a claim be processed and honored if successful. So it wasn't the same directive. It was very similar, but there was considerations now relating to PMBs and EMCs. So it was a slightly different directive, is really the important point. And the third directive related to provision of the Act, and we'll go through, and I'll just explain this provision of the Act. The fund or an agent shall not be obliged to compensate any person in terms of Section 17 for any loss or damage where the third party has entered into an agreement with any person other than the one referred to in that subparagraph, in accordance with which the third party has undertaken to pay such person after settlement of the claim a portion of the compensation in respect of the claim. So there's a lot of words, but what it means is that the Act says that the fund will not pay out where there's an agreement with a third party to pay a portion of the claim. Now, the question was whether that relates to medical aid schemes. And I will tell you that what the court found in this Van Wyk case is that in fact didn't relate to that. That related to the type of agreement where, in the old days, like called a Champati agreement, where somebody funds litigation. That's what that particular section was aimed at defeating. It had nothing to do with whether past medical expenses had been paid by a medical aid scheme or not. And I think that's quite a strong argument. If one looks at the language of that section, the intention of that section, it doesn't seem, to my mind, to fit neatly into the idea that is related to the medical aid schemes paying for PMEs. So that, and we will see, but more importantly, the full bench in Van Wyk's case said that that was in fact not what the section was aimed at, and therefore that second practice directive was not valid and should be set aside. Okay, and then after considering these two cases and other decisions in the division dealing with the Road Accident Fund stance on the payment of past medical expenses, the Road Accident Fund now applied for leave to appeal for the second time before the trial court. So now there's a second application for leave to appeal. Then the Supreme Court of Appeal eventually granted that leave, and that was what then went through the courts and came up before this particular full bench and in this particular judgment. Okay, and then the court deals with, here in these paragraphs, deals with these questions relating to the virtual platform and the postponement, and that is fairly straightforward. I think we've dealt with that. The court actually eventually found that it was unfair not to have allowed the person to testify, but nonetheless said because liability had been conceded, it wasn't relevant. The unfairness was not something which affected the ultimate judgment, and so continued to decide on these two practice directives. And this is all to do with the settlement and what happened there. And then so that effectively disposed of the procedural aspect, in other words, the virtual hearing and whether postponement should have been granted, and it left this court to deal with this question of past medical expenses. Now, if we look at the grounds of appeal, the RAF raised various grounds of appeal against the court or quo's findings. The grounds of appeal, as discernible from the notes of appeal, was summarized as: the RAF submitted that the court or quo erred in its application of the law related to postponements, and so this is to do now with the postponements and the virtual hearing. And so we're not too concerned about that. And here we come to the issues for determination. And this all relates now, the first two relate to the procedural aspects of the virtual hearing and the postponement. And in fact, as I said, the Road Accident Fund was successful on those two. But then it left the third issue. And the first point I want to make with these issues is, once again, and should be noticing by now if you are following these tutorials, that in the beginning of every judgment, or towards the beginning, the judges are very, very careful about identifying exactly what issues are raised for determination. And you see this happens again in this particular judgment. So when writing your reports, bear this in mind. The judges are looking for what issues do I have to determine in this case? What are the issues? What has been agreed and what is in dispute? It really is something that you should pay attention to in your reports. And remember, we looked at that previous judgment where not only at the outset of the matter, but these things change over time. So be aware of the current state of play. In other words, any addendum reports, supplementary reports, have regard to joint minutes. Have there been further joint minutes? Make sure that you're always abreast of what the issues are as they crystallize as the trial proceeds, because the judges will be laser focused on what those issues are when the matter starts. You must be able to address the court on that. All right. Now, the third issue is whether the court or quo was correct in making an order directing the Road Accident Fund to pay the past medical expenses, notwithstanding the decision of the full court in Discovery Health 2. So what happened here in this case, the court, remember, directed the defendant to pay, notwithstanding the fact that there was this other judgment out there saying that those two practice directives were not unlawful. And then incidental to this question is whether the application of the RAF's two subsequent directives was res judicata. Res judicata means it's a decision made, the court's decided this matter, you can't revisit it, and whether these directives applied retrospectively. Okay. And then what the court goes through, and this court now, and remember, this will still go on appeal to the Supreme Court of Appeal, but this court gives an interesting insight into how the courts are going to approach this particular question. And you'll see that the court held that while the RAF did not meticulously follow the Uniform Rules and Practice Directives in respect of the presentation of evidence, it was happy on those first two issues to find in favor of the fund. Okay, now when we get to the past medical expenses, the court sets out those various directives, which we've discussed, that deals with Mbongwe's case, which we've discussed. And then the court concluded that the medical aid scheme benefits which the plaintiff has received, will receive, are not deductible in determining his claim for past and future hospital and medical expenses. It is common cause that the RAF's application for leave to appeal failed before Mbongwe, the SCA, and the Constitutional Court. Notwithstanding that, the second and third directives were issued, and we've had a look at those directives previously. We don't need to go through those again, but those who want to look at it closely, it is in those paragraphs. And then we get to this judgment in Discovery Health 2. And this is really the issue that emerges with past medical expenses. All of this is by way of background. But here we get to the real intellectual challenge. Is from Discovery Health 2, which was the full court decided that the second two practice directives were not unlawful. Now, within that judgment, you can see two schools of thought. And the struggle now is which school of thought is going to prevail overall with past medical expenses. The first school of thought, articulated by the majority in Discovery Health 2, posits that despite Judge Mbongwe's ruling on the 27th of October, which reviewed and set aside the initial directive of the Road Accident Fund issued in August 2022, in which the Road Accident Fund instructed its employees to reject past medical expenses that a medical scheme had paid, the two subsequent directives the Road Accident Fund issued regarding the rejection of similar claims did not fall foul of Mbongwe J's order or interdict. So now we start understanding the whole, it seems so complicated, but now there's like a light shining on this thing, okay? Right, what do we know? We know that Mbongwe gave an order in terms of which he set aside the first directive, but that wasn't the end of the story. He also said, but I'm also going to interdict the fund from issuing similar directives, invalidating the payment of past medical expenses. And the question that now arises is whether those two directives fall within the ambit of that interdict. In other words, were they dealt with by Mbongwe in the original judgment, or do they fall outside the ambit of what he dealt with? And that's where the two schools of thought emerge. The one school of thought is they do not fall foul of Mbongwe's interdict, and the other school of thought is that they do fall foul of Mbongwe's interdict. And just to bring this down to a sort of practical level, the contest, one of the issues in dispute here is whether the Road Accident Fund is now trying disingenuously to sort of manufacture a situation where Mbongwe's made a decision. The courts have decided that first practice directive was unlawful. You cannot prevent payment of PMEs. And that issue now stands. And now the argument is that the Road Accident Fund in the subsequent two practice directives were just trying to find a fancy way of getting around that particular interdict. Or, on the other hand, is it genuinely a different situation and those two subsequent practice directives don't fall foul of the interdict? Okay, so that's actually the issue. And if you have a look at the top of paragraph 751, put differently, the first school of thought holds that the subject matters addressed in the two subsequent directives do not fall within the scope of the Mbongwe J order. In other words, the two subsequent practice directives are not covered by the first order, and therefore they can now be considered by the courts. Furthermore, this school of thought opines that medical schemes cannot be compensated through their members for what they've paid in discharge of their contractual and statutory obligations. So now there's another related issue, and that is this question of should medical aid schemes be compensated through their members for what they've paid in terms of their contract with that member. In other words, when the question is when the medical aid scheme pays out, is it entitled to recover that money, or does it just lose that money? And that's an issue related to that first school of thought. All right, so that's now a very important ancillary issue that comes up. Then let's have a look at the second. So that's the first school of thought. And in summary, the first school of thought is saying these two subsequent directives don't fall foul of the interdict. The courts can decide whether they're valid or not. And by the way, we need to, the question of whether medical aid schemes can recover that money or not will be considered as part of that equation. That's the first school of thought. The second school of thought is it was expressed in there was a minority judgment in Discovery Health 2. It believes that the issues raised in the second and third directives do fall within the reach of Mbongwe's order and are thus what we call res judicata. And remember, res judicata is the issue's already been decided. You can't now go and bring additional directives. Mbongwe dealt with this thing and he interdicted you from doing this. You're doing exactly what he interdicted you from doing. And then the second school of thought believes that there is a single primary ratio which underpinned the entirety of Mbongwe J's judgment and determines the meaning of its orders, including the interdict. Namely, and that this is the second school of thought says this was the reasoning which Mbongwe adopted, and so it applies to the second two directives. It is unlawful for the RAF to reject a claim for past medical expenses on the ground that a medical aid scheme has already paid for those expenses. Okay, so the second school of thought says Mbongwe made the decision that the fund cannot refuse to pay for past medical expenses because medical aid has paid, and that's an end of it. And all the rest is just a sort of subtle way, or maybe not so subtle way, of getting around the interdict. That's essentially the issue that came up in this particular judgment before the Cape full bench. And then just to take it to the next point, this is now just deals with some background legal principles, but basically this deals with the principle, as I mentioned earlier, that the courts don't like to double compensate. So they will not allow a plaintiff to be double compensated. And the Road Accident Fund was effectively making the argument that there's double compensation in this case because the medical aid scheme had paid out, and now the fund was expected to pay out. Okay, and then but it's not. But that principle of double compensation is not cast in stone. It's a bit more subtle than that. There are exceptions, and the judgment then considered an exception, which is it is well established in our law that certain benefits which a plaintiff may receive are to be left out of account. In other words, some benefits that a plaintiff receives are not deducted from the compensation which he or she gets. And the classic examples are benefits received by the plaintiff under ordinary contracts of insurance for which he's paid premiums, and B, monies and other benefits received by a plaintiff from the benevolence of third parties. So basically charity or sympathy. So insurance and charity generally are not deducted from the amount which a wrongdoer has to pay. And we have a look at that's called the collateral source rule. And when you see past medical expenses discussed, you'll see this collateral source comes up all the time, or raised inter alios acta is another name for it. Same thing. You see here at the bottom of 60, they refer to raised inter alios acta. It basically is items which are left out of the compensation which the fund must pay. So they're not deducted. The rationale for the collateral source rule is that the defendant should not benefit from the plaintiff's foresight in acquiring insurance. Expressed differently, the plaintiff should reap the benefits of the bargain he or she has made for insurance. This collateral source rule requires the party responsible for causing the injury to compensate the victim for all the harm caused, not merely the net loss suffered by the victim. In other words, a wrongdoer can have no concern with the transaction between a plaintiff and his insurer, and there's no equitable ground to grant the wrongdoer a windfall by allowing him a credit for the payments that the insurer made. Now, what that really means is that the law approaches it on this basis. The law says it would be unfair for the wrongdoer to benefit from the prudence of the person who's being compensated, of the injured person. So why should the plaintiff pay and out of his or her hard-earned money every month got to pay for insurance, and when he gets injured, that now falls to the credit of the wrongdoer? Or I think a little bit easier to understand that principle is the other exception, which is the charity one. So let's say somebody gives charity. Why should that charity then go to the advantage of the wrongdoer? So it seems as though that charity should not be to the advantage of the wrongdoer, and that's why the law leaves that out of the picture. Okay, so that's the reason for this collateral source rule. But then I just want to get to this point, and to my mind, this is a very strong point, and it's going to be very interesting to see how the Supreme Court of Appeal deals with this particular dictum by Zondi. And this is Judge Zondi, who then became the Chief Justice subsequently, a very highly respected judge, and to my mind, a very sound and sensible judge. And he actually dealt with this issue, and it's very interesting looking at how he reasoned it and he applied his judgment to it. Let's have a look at this paragraph. It is paragraph paragraph 63. And this judgment by Zondi is referred to with approval by the full bench in this particular Van Wyk case. Zondi, as he then was in Rai versus Road Accident Fund, had to determine whether the RAF was liable to the plaintiff for the payment of past medical expenses in the sum of $58,000 in that case. The relevance of the question arose because Benitez had already paid the plaintiff's medical expenses. So exactly the situation. There was now an injury, motor vehicle injury, the medical aid paid, and now there were past medical expenses. The plaintiff asserted that the RAF was liable to pay her the amount of $58,000 in terms of the doctrine of subrogation. We don't need to worry about that. That just means that she now has the right to claim on behalf of the insurance company. While the RAF, on the other hand, contended that it would not liable to pay the plaintiff the amount of $58,000, as this would amount to enrichment because Benitez already paid her, and that Benitez must claim the amount from the defendant whose claim had prescribed. The court rejected the RAF's argument that the plaintiff cannot claim for the past medical expenses after payment of such expenses by Benitez. In other words, the court said, no, the Road Accident Fund must pay these past medical expenses per Zondi. And here's Zondi's reasoning. Look at this paragraph 15 of that Rai judgment. In my view, settlement by Benitez of the plaintiff's past medical expenses does not relieve the defendant, i.e. the Road Accident Fund, of its obligation to compensate the plaintiff for the past medical expenses he incurred. Payment by Benitez was made in terms of the undertaking made by the plaintiff to Benitez, in terms of which Benitez agreed to settle the plaintiff's past medical expenses. So there's a contract with your medical aid that if you get injured, the medical aid will pay, right, your medical expenses. And here's the important bit. On the understanding that upon a successful recovery from the defendant, so if the defendant pays out for past medical expenses, the plaintiff would reimburse Benitez for all the costs it incurred on plaintiff's behalf in connection with the claim against the defendant. In other words, the contract is actually that whatever you get paid by the Road Accident Fund needs to go to the medical aid scheme. The plaintiff doesn't hold on to that money. It's, to me, a very important fact, a very interesting angle on this argument. And then it carries on at 16. The obligation which the undertaking imposes on the plaintiff towards Benitez does not arise until such time that there is a successful recovery of the past medical expenses by the plaintiff from the defendant. So, in other words, it's only once the plaintiff gets paid by the Road Accident Fund that there is then a duty on the plaintiff to pay that money over to the medical aid scheme. The defendant primarily remains liable to the plaintiff for the payment of the past medical expenses, and the liability of Benitez to the plaintiff for the past medical expenses is secondary to that of the defendant. The defendant should pay the past medical expenses to the plaintiff, who should, upon receipt of payment, account to Benitez in terms of the undertaking. And then 17, the undertaking given by the plaintiff to Benitez creates a contingent liability, which is, in other words, that liability may or may not arise. which is enforceable on the happening of some future event. Bonitas, in other words, the future event is if that plaintiff gets paid, then there's a duty on the plaintiff to pay out to the medical aid scheme, in this case, Bonitas. Bonitas's right of recourse against the plaintiff for reimbursement does not arise until the plaintiff has received payment from the defendant. The defendant's liability to the plaintiff for the payment of past medical expenses is not affected by Bonitas's payment on behalf of the plaintiff. In other words, and then just before I explain that, there were similar sentiments echoed by Davis, J. and Moydeen versus the Road Accident Fund, and there are a number of other judgments which are referred to. But what these judges are also
105 to 60
is that, sorry, can we please just mute that? Someone's unmuted. Just quickly mute you all. So what that amounts to is the following. If we look at what these judges are saying in these judgments, is that, in fact, there's not double compensation. Because which is the Road Accident Fund's primary argument. Because what actually happens is that where the Road Accident Fund pays out for an injury, where there's previously been payment for past medical expenses by a medical aid scheme, what happens in terms of those contracts is a clause then kicks in, which obliges the plaintiff, once it receives that money, to pay that money out to the medical aid scheme. And therefore, the plaintiff at the end of the day doesn't get double compensated. And an ancillary to that is, why should the medical aid scheme have to lose that money when the Road Accident Fund is duty bound to pay out on injury? So it's a very interesting point that's taken by Judge Zondi in that Rai judgment, and which has been followed by Judge Davis, who does a lot of the personal injury work in the South Gauteng division. And there are a couple of other strong judgments with very similar approach to the situation. So that, and then just to finish off on this judgment from yesterday, and that line of reasoning found favor with the court in the Western Cape yesterday. In other words, what the court in the Western Cape yesterday had a look at that reasoning, adopted that reasoning, and then insofar as the directives are concerned, it looked into those directives and found that that reasoning by Mbongwe was basically that the fund could not refuse to pay out for past medical expenses based on the reasoning process, which I've just explained to you, and the fact that the second and third directives dealt with slightly different issues didn't save the Road Accident Fund. It still fell foul of the interdict because the basic premise of the interdict was that the Road Accident Fund couldn't refuse to pay out on past medical expenses where the medical aid scheme had paid out. And an important consideration there was because there was not, in fact, double compensation once the proper structure is understood. Okay, so just to wrap up, this judgment is one which, as I said at the outset, there are a number of points to make here. Firstly, it does seem like a very technical legal judgment, and there are points at which it is quite technical and legalistic. But I've taken you through the rationale, and I hope that you can see that from this judgment, actually, there's a logic to the approach which the courts are taking. There is, and one must be fair-minded about this, and one must understand the arguments properly. The Road Accident Fund's argument about double compensation does seem initially attractive. There is a valid point, and that's why you get split decisions. And you have judgments of a senior court, which is a full bench, saying that the Road Accident Fund is quite right, that they would be overcompensating the plaintiff in these circumstances. We then have other judges. We have another full bench decision, which goes the other way and which says, no, there won't be double compensation for the reasons that we've looked at in this tutorial. Now, it remains to be seen what the Supreme Court of Appeal and probably the Constitutional Court will make of these arguments. But what I've hoped to help you to understand today is what's going on with these PMEs beneath the surface. And so when you read news articles on it, or you have discussions, or you're busy with this in your practice, you have a more informed view of what's going on beneath the scenes, under the water. And that then gives you, at the end of the day, the most precious thing, which it gives you a sense of empowerment over the work that you're doing. You've got a fuller understanding you're more informed about what's going on, and that will give you a surer grip on when you deal with these particular issues. So, yeah, that was an interesting judgment. I was hoping to deal briefly with Holzhausen versus Rust, but it's not a critical judgment, not a very lengthy judgment. And I think what I will do is I will just work that into next week's presentation that deals more with the general principles relating to the admissibility of expert evidence and psychologists and psychiatrists, and we start touching on discipline-specific work, which we will be doing over the course of of this term. Just to wrap up there, you will have noticed on the group notice that the training program for the first term will commence now in this week, and it'll run for February and March. We have already been doing training. We've finished the advanced training program, but we're starting now with the introductory program, which starts this week, and we will then continue through. Please have a look at that program. I'll put links onto the group. You can go and have a look at that. And there are also ways that you can sign up if you want to take your learning to a further level and you want to improve your understanding generally of what it is that you're doing. And finally, to wrap up, what we do at the Medico-Legal Reports is we try to advise experts on what it is that they need to know about what the judges want and expect from experts. This particular tutorial is not specifically on point in that regard, but nonetheless, it's a topical issue. It's an important issue that's in the courts all the time. It's coming up a lot in the media, and that should give you a more informed view of what's going on behind the scenes and to understand how the courts operate. Again, I thank you for your time, and I look forward to starting the training with those of you that signed up. We will be putting out posts and directives over the next few days. Thank you very much.